defending the algorithm. The historic $1.5 billion settlement, what the Bartz versus Anthropic copyright case means for AI and creative industries. My name is Henry Sneath, and I'm your narrator. I will also provide some commentary outside of the written text in our blog. I'm a business trial lawyer in Pittsburgh, Pennsylvania, and I specialize in patent, trademark, copyright, trade secrets, and other intellectual property and AI-related business litigation. Defending the Algorithm is the title of a series that I have developed for blogs, podcasts, and hopefully video down the road. I edited this installment, and it was authored completely by Claude, AI from Anthropic Sonnet Edition 4. Claude can make mistakes, so please double-check this content if you intend to rely on it. This post relates to the recent case ruling and opinion in Bartz v. Anthropic, filed in the Northern District of California at doc number 24-CV-05417-WHA. Here's our introduction. The artificial intelligence landscape shifted dramatically this month when Anthropic, the company behind the popular Claude chatbot, which helped with this blog, agreed to pay $1.5 billion to settle a class action copyright lawsuit brought by authors and publishers. This landmark settlement, which is awaiting court approval from Judge William Alsup in the Northern District of California, represents, if it is approved, the largest copyright recovery in U.S. history, and it establishes important precedents for how AI companies can legally use copyrighted material to train their LLM systems. LLMs are large language models, which create the backbone of AI. The massive compute in AI is based on the training of the AI model, models like ChatGPT, Gemini, and Anthropic, Claude, which helped with the blog in editing and writing. The LLMs work by essentially downloading the entire internet as background for the model to apply probability mathematics in an algorithm or mathematical set of instructions to predict the next word in a sentence. AI generates responses to queries by using the data which it was programmed or trained to absorb, and by analyzing the data at blazing speeds to recognize patterns in that massive data, and then it makes the most likely predictions that generate a response to your query. Chapter 1. The Foundational Legal Framework, Judge Alsup's Groundbreaking Ruling. This recent settlement follows up on Federal Judge Alsup's pivotal June 23, 2025 summary judgment decision in Bartz versus Anthropic, which created the first substantive bright-line judicial framework for AI copyright law. Judge Alsup's ruling fundamentally shapes how copyright law applies to artificial intelligence training by establishing a crucial legal distinction between permissible and impermissible uses of copyrighted material. In his fair use analysis, Judge Alsup found that training AI models on copyright works constitutes fair use when the copies are legally obtained. Applying the four-factor fair use test, he determined that the use was quintessentially transformative, which is key in copyright law, because AI systems don't replicate works but instead create fundamentally different outputs. He analogized AI training to, quote, any reader aspiring to be a writer who studies existing works, not to race ahead and replicate or supplant them, but to turn a hard corner and create something different, end quote. This transformative use analysis is particularly significant because it focuses on the AI's ultimate purpose, providing responses to queries, rather than the intermediate copying that is done during the training of the AI LLM model. The decision suggests that courts may view AI training as sufficiently transformative to overcome both the commercial nature of the use and the wholesale copying of protected works, two factors that typically weigh against fair use. And I'll comment just on transformative use. Transformative use here presumably means that while downloading entire copies of books into the LLM database, these books were stored in a way to be used for a different type of output when creating responses to queries. The LLMs and their AI counterparts are looking to predict the next likely word in a given sentence, and they use the training materials from which to determine what is the most likely. That constitutes the transformative use. Fair use, the concept that Judge Alsop applied, is a defense to claims of copyright infringement. If I'm teaching at a law school class, for example, on trade secrets, which I have done, I can show the students PowerPoint slides with exact copies of copyrighted works because it's an educational use, a fair use. The same thing applies to people writing historical books or news presentations, a variety of ways that people can use copyright works in a fair and legal way, hence fair use. If you prove fair use, you defeat a claim of copyright infringement against you. Judge Alsop also addressed Anthropic's digitization of legally purchased books, ruling this too constituted fair use because the company simply, quote, replaced the print copies it had purchased for its central library with more convenient, space-saving, and searchable digital copies, end quote, without adding new copies or redistributing existing ones. Judge Alsop, however, found that certain AI training actions constitute piracy, and he denied summary judgment, and he was prepared to allow this piracy issue to go to trial. I will talk about the piracy element shortly. Chapter 2, the four-factor copyright fair use test, which is found at 17 U.S.C. Section 107, which is the federal copyright statute. Under U.S. copyright law, the fair use defense to claims of copyright infringement is determined by evaluating four factors. Factor 1, the purpose and character of the use, including whether it is transformative and commercial. Number 2, the nature of the copyrighted work, with factual works receiving less protection than creative ones. Factor 3, the amount and substantiality of the portion used relative to the whole work. In other words, how much was actually copied. And factor 4, the effect of the use on the market for or value of the original work. In other words, does this use dilute the value of the original copyrighted work? In the Anthropic case, Judge Alsop found that the transformative nature of AI training, in other words, creating entirely new outputs rather than simply reproducing existing works, was so compelling that it outweighed factors that typically disfavor fair use, such as the commercial purpose and the copying of entire books. That was the four-factor analysis that led him to make his decision that it was fair use to download legally obtained books that were purchased. Chapter 3, the critical piracy distinction, summary judgment denied. Judge Alsop rejected Anthropic's argument that downloading books from piracy sites like Library Genesis should receive the fair use protection just as the legally downloaded books received. His decision creates a bright line rule that could become central to AI copyright jurisprudence. The fair use defense for AI training depends entirely on lawful acquisition of source materials, according to Judge Alsop's opinion. And if that becomes precedent across multiple jurisdictions, it could become a nationwide precedent. Companies cannot cure illegal acquisition through fair use claims about subsequent training purposes. The piracy sites are deemed by Judge Alsop to be sites housing pirated, in other words, illegal works, so that the use of those materials as training material is also illegal. So in other words, if someone else got it illegally and you obtain it illegally by simply downloading it, you're the bad guy just like the original pirate. The judge wrote that Anthropic downloaded for free millions of copyrighted books in digital form from pirate sites as part of an effort to amass a central library of all the books in the world to retain forever. He explicitly refused to treat pirated library copies the same as legitimate training materials, allowing the author's piracy claims to proceed to trial. That trial was set for some time later this year. Chapter 4, the financial impact and the settlement terms. This settlement, if approved by Judge Alsup, will obviously stop the case from going to trial on the piracy claims, which Judge Alsup refused to dismiss. Under the settlement terms, Anthropic will pay approximately $3,000 per book to roughly 500,000 affected authors. The company has also agreed to delete the pirated works it downloaded from shadow libraries. This substantial payout comes at a time when Anthropic recently completed a $13 billion funding round, bringing its total valuation to approximately $183 billion. At a subsequent first hearing, to present evidence to Judge Alsup in support of him approving the settlement, he declined to approve the settlement at that time, but requested more information on the authors who will receive payments and other details about the nature of the settlement. He then had a second hearing just recently and has tentatively approved the settlement, but continues to need some additional information. We will follow the case and deliver another post when the Bartz case is concluded. The settlement sends a clear message to the AI industry about the financial consequences of using illegally obtained copyrighted material. As Authors Guild CEO Mary Rassenberger noted, this historic settlement is a vital step in acknowledging that AI companies cannot simply steal authors' creative works to build their AI. Had Anthropic proceeded to trial on the piracy claims, experts estimated that potential damages could have reached multiple billions of dollars, enough to potentially cripple the company, given that the statutory damages for willful copyright infringement can reach $150,000 per work. Chapter 5. Industry Implications and Future Framework for AI and Copyright. While Judge Alsup's Northern District of California ruling isn't binding nationwide, it provides the first substantive judicial bright-line guidance on AI fair use that future courts will undoubtedly reference. It's a bright line because it distinguishes between legally and illegally obtained materials used for LLM training. The decision will likely encourage more proactive and legitimate licensing arrangements on the front end, while establishing clear liability for companies using pirated training data. Industry experts view this development as the beginning of a necessary evolution toward a legitimate market-based licensing scheme for training data, rather than the end of AI innovation. In other words, it was seen as a positive business development in the AI industry, at least by most experts. This settlement agreement may encourage more licensing agreements between AI companies and content creators, fostering a sustainable ecosystem where creators receive compensation while AI companies gain legal certainty. For businesses and creators alike, this case establishes that AI companies can legally train on copyrighted works obtained through legitimate channels, while facing significant liability for using pirated materials. As the technology continues to evolve, we can expect this potential precedent to influence how AI companies source and license training data going forward. That's all for today. Look for future posts and audio presentations at our website, www.hh-law.com. My thanks to Claude for assistance with this Defending the Algorithm series. Houston Harbaugh's AI and intellectual property team in Pittsburgh will continue to monitor developments in AI and the law. For questions about how these changes may affect your business or creative work, please contact me in our office at my email address, sneathm@hh-law.com, or call me in my office at 412-288-4013. Thanks for listening. See you next time.